All right, it looks like we have a pretty good group here. Everybody ready to go? I think we'll get started. Great. So thanks for joining us, everybody, for MCEA's CLE celebrating the 50th anniversary of the Minnesota Environmental Rights Act, MERA. We are so glad that you joined us. We have a great program planned for you today, and we're excited to have all these panelists with us today. I'm Kevin Ruther, MCEA's Chief Legal Officer, and I'm going to be your host today. I have a few things just to go through before we get started. First of all, this is a free CLE and it's been approved for 2.5 credits. The event code, if you want to make a note of it, is 419992. And I'm guessing somebody might put that in the chat as well, 419992. We have 3 50-minute sessions planned. The first panel is on the history and the origins of MERA. And then at 2 o'clock, we'll have a bit of a teach-in on the nuts and bolts of the statute and some of the leading cases. This will be a good one for students, or if you're new to the area of environmental law. Then at 3, our panel will consider very recent cases and where MERA might be headed in the future. So we'll have a short intermission in between each of those panels. You'll have an opportunity to go get some tea or check your email. Next, we have an amazing group of people who've joined us for these panels today, and their bios are very long. And so I'm not going to be reading off all of their bios, but I want you to know that they are on our website at mncenter.org/CLE, and I really encourage you to go out and see the bios there. When I introduce people, it's going to be pretty quick so that you get to hear from them rather than about them. And then finally, we're definitely interested in your questions. So at the end of each of the panels, we'll try to leave some time for audience questions. And the way to get your questions answered is to use that Q&A box at the bottom of your screen. There's little bubbles there, it says Q&A. Type your question in there. I'll be monitoring those, and we'll get to as many of them as time allows. So we want to get started with the first panel and welcome our first panelists. Stephanie Hemphill, hi Stephanie, is with us. She's going to moderate this first panel for us, and if you're an NPR listener as I am, you will recognize her voice. Stephanie is a longtime NPR reporter on the environment beat. She recently retired a few years ago now, I guess, and has founded a magazine, Agate Magazine, which you can check out on the internet. So thanks, Stephanie, for being with us. And joining her are Chuck Dayton and Grant Merritt and Alex Klass. Chuck and Grant are longtime environmental advocates and attorneys and were around at the time that MERA was enacted. Alex is a professor at the University of Minnesota Law School, and she teaches in the area of environment and energy. So thank you all 4 of you for being with us for this panel, and I'll turn it over to you, Stephanie.
Thank you, Kevin. And I'm so pleased to be here to see my 2 buddies, Chuck and Grant, and so pleased to meet Alexandra, Professor Klass. I've read some of your articles, and so I'm happy to be able to interact with you now. So we're talking about 1971, and that's a long time ago. It's before some of us were born. I suppose there's some people, young people tuned in here. So I'm going to ask Chuck to set the scene for us. What was happening in those days back in 1971? What was happening in the society, and what was available in the law to protect the environment back in those days?
Well, this was the year after Earth Day, and the environmental movement was riding a crest. When I was in law school a few years before, there weren't any courses in environmental law. There wasn't a field named environmental law, except maybe nuisance and the public trust. But by 1971, the National Clean Water Act had passed, the National Environmental Policy Act had been signed, and it was becoming clear that the law could be used as an agent for change. So I was with a firm in Minneapolis, and one of the lawyers, John Broker, who was a lobbyist for the firm, learned about the the Environmental Rights Act bill that had been introduced by Wendy Anderson in the previous session, as Grant will tell you. And that was the product of work by a Michigan law professor named Joe Sachs. And Sachs had written a book called Defending the Environment, the Strategy for Citizen Action. And so we copied that bill and went out and found Republican sponsors, because at that point, both houses were controlled by the Republicans, and introduced the bill.
Well, let's get Grant to tell us about what you had done a year or so earlier with Wendell Anderson, who at that time was not the governor yet. Grant, can you hear me?
Yes, I can. I got started before I learned about the Sachs bill because of my involvement in the reserve mining case, which I learned about from my uncle, Bill Matson, up at East Beaver Bay. So from 1967 on, my involvement was as a lawyer, but not a paid lawyer. I was just a citizen activist. And I could see that the environment needed a better law, especially because we soon learned during the course of appearances before the Minnesota Pollution Control Policymaking Board and the Federal Environmental Protection hearings that we needed to shift the burden of proof to the polluter. So that came up in the 60s, 67, 68. And then the first environmental enforcement conference under the federal law began in May of 1969. And by that time, we had formed a new environmental group called the Save Lake Superior Association. And I had joined MECA, Minnesota Environmental Control Citizens Association. And right after that first May 1969 hearing in Duluth, I got a call from Wendy Anderson, wanted to have lunch along with David Lebadoff. So in May of 69, we met over at Sheik's, and we talked about political action, because it was obvious to all of us that the environmental movement had to have political scientists. They were just as important as the ecologists, in my mind, maybe more so. And so I told both Lebadoff and Anderson about the Sachs bill, because I had read it. I think I first saw it in 68 around then in an American Bar Association publication. And I was doing a lot of reading by this time, and had met Chuck Stoddard, the fearless public servant up in Duluth, which is my hometown. And because of my longtime involvement on the North Shore, I was principally involved with the reserve case. And Wendy Anderson, right away, as soon as I told him the quick details of the Sachs bill, says, "I would like to introduce that. Have you got that bill?" "Yes, I have it in my office. I'll send an aide over this afternoon." That's what she did. And I think what intrigued him the most was the shifting of the burden of the proof, and also the feasible and prudent alternative language in that bill. We talked about that. And so Jim Weiler came over to my office. I gave him the bill. Wendy introduced it in the last 2 or 3 days of the 69 legislative session. He was then a state senator. And his background, by the way, was both in the House and the Senate, which helped a great deal as governor, because as Chuck points out, the Republicans were in control, although they weren't designated as DFL or Republicans. They were either liberals or conservatives. And by that time, one of my favorite politicians, Gordon Senator Gordon Rosenmeyer, had conceived the idea of the policymaking citizen board of the Minnesota Pollution Control Agency. And that passed in 1967. And that we've lost that. And we've also lost the Federal Enforcement Conference procedure, because those two laws caused the development of public opinion on the environment. And so the Sachs bill then was introduced again, as Chuck points out, in the 71 session. And meantime, I think probably due to John Broker, this group of maybe 3 or 4 lawyers over at Great Pine Moody were meeting, and I got invited somehow to attend a couple of those meetings. And that's where the bill was then prepared based on the Sachs bill.
And I want to ask you, Grant, I want to ask you about one of the chief benefits of the MERA bill, which I understand is something called standing. And it changed the standing provisions about protecting the environment. So can you explain what that means?
Well, it gave any citizen in the state or around wherever in the country the right to start a lawsuit. And so any of the citizens or residents could begin a lawsuit, and the first thing you had to do was to prove the prima facie standard, pollution, impairment, or destruction of the environment. And then the shift occurred to the polluter. And so that was based on this revolutionary law that Professor Sachs came up with.
Yeah.
And later on,
let's hear about the process at the legislature, Grant. Let me turn to Chuck, because you've told me that you were the first person to testify in favor of the bill, but you've got your young lawyers working together. How did it go? And how did it go during the session?
Well, before I get to that, let me add to what Grant just said about standing. Some environmental cases have been hung up because of the problem that the person who was bringing the act could not show that they were personally affected by the conduct being challenged. And so this bill gets over that hurdle by allowing you to bring an action on behalf of natural resources, whether or not you can show that you personally are affected by it. So I could bring an action challenging something up on the Red River of the North, even if I'd never seen the Red River of the North. All right, so get to your question. So I testified, I basically talked about the Michigan bill and how it would work. And the opponents of the bill, corporate Minnesota, said, well, what if what we're being challenged about is the subject of a permit and we're doing something that's lawful? And so that would be unfair to be able to sue us for that. And your bill seems to allow that. Well, we said, what if it's a lousy permit and it doesn't protect the environment? So a section 10, next to the last section in the bill, was added to allow the plaintiff to challenge a Minnesota regulation that is alleged to be a cause of pollution, impairment, or destruction. For 50 years, that statute was not used, and it's a wonderful statute. Finally, it's being used to challenge the sulfide mining regulations, and that matter is now back and been to court. The court sent it to DNR. The hearing is coming up soon, and I am delighted that that process is underway. Another argument against the bill was, well, what about scenic and aesthetic resources? What if somebody has an old barn on their property and you think it's a great old barn and it's a scenic and aesthetic resource and they want to take it down? So scenic and aesthetic resources were limited to those that are located on publicly owned land. Another argument was, well, what if I'm doing something that's legal on my own land that you don't like, and you think it may violate the standards? There was an exception put in that says you can't sue somebody for doing something on their own land unless it has an extraterritorial effect. So if something was causing an odor, for example, that went over your property line, that would be a different matter. Or noise might be another extraterritorial effect. What about odors? Odors are actually exempt if they are in violation of a permit. It's not a total exemption, but that was one of the handoffs to farmers. And then farmers objected that, you know, we could be sued for anything. People don't like the smell of manure. And we're just worried about this bill. So basically, family farmers were exempted from the bill. And that was a purely political thing to get the votes.
Because the rural parts of the state had a lot of power at the legislature then, as they do now.
Always have. Yes.
I got the impression.
Stephanie, let me add to what Chuck said about noise, because we passed noise, and that was included later on in '72. So noise is part of the MERA law.
Mm-hmm. But it sounds like the whole process of getting it passed. I had one. By the way, these two gentlemen I'm talking with now are part of an oral history project that we did, in which I interviewed 9 people, and that is housed at the University of Minnesota Duluth Archives. And so if you want to learn more, you can hear those whole interviews. And in that process, one of the gentlemen told me that passing MERA was easier than passing some other later environmental bills. And it was because people hadn't woken up to what could happen as a result of these bills. And so there wasn't terribly much opposition. Is that how you experienced it, Chuck?
Yeah, I think you in the article that you wrote for the Minnesota Historical Society Press, I think you pointed out that the vote was unanimous in the Senate, and there may be 20% opposed in the House. It was a time when we were riding the wave of environmentalism, and everybody wanted to be green. And frankly, the opposition hadn't been as well organized at that point as they are now, although they did have professional lobbyists. So what I've said is, you know, I commiserate with the current environmental lobbyists, because back in those days, I mean, we hit home runs, but the wind was blowing 50 miles an hour from behind home plate, and now it's blowing against you. So it's much.
I'd like to add something on that. We did have a lot of opposition in '71, and the major opposition was by Ted Shields, lobbyist for the Chamber of Commerce, then known as Mackey. And I remember sitting in the gallery when Senator Jack Davies, tried to take out the language that economic considerations alone cannot provide a defense. And the vote on that failed by a very close margin, 40. So Shields was involved, the chamber, but it wasn't like later on when we got to '73 and the Minnesota Environmental Protection Act that we had much more opposition, as Chuck knows.
Policy Act. Yeah, and I wanted to just take a minute and mention some of the more prominent, at least one of the more prominent Republicans who were supporting you, because they were just as much in favor of it as anybody else. And of course, right now I'm blanking on the name, but you'll.
Well, the authors were Winston
done.
Borden in the House and William Kirchner in the Senate. And Robert Dunn was there, I think, at that time, who was a leading Republican, very much an environmental guy.
That's the name I was trying to think of, yeah. Okay, well, so this was kind of a watershed bill and or law, and it's made a lot of difference for the way we do things in Minnesota. And some of the language, which is key in there, I believe, is it makes it illegal to do something which materially adversely affects or is likely to materially adversely affect the environment. And then the defense has to prove that it has no feasible and prudent alternative. And as Chuck just mentioned, economic considerations are not alone are not a defense. So Chuck, explain more about that.
But this is a remarkable standard. I think Alex will agree that unique language, very, very powerful language. And it comes out of, I think, the Federal Aid Highway Act and a 1971 decision by the Supreme Court, where there was an effort to put a road through a park. And this kind of language was in the Highway Act, feasible and prudent alternative. And the court said, it doesn't mean that it just costs more, it's easier. There has to be truly unusual factors resulting in community disruption or the cost has reached extraordinary magnitude. So the Supreme Court said it has to be really, the alternative has to be really, really hard to do and costly to make it not feasible and prudent. So that's the standard. That's the standard that's being interpreted by the courts in Minnesota. And I wanted to print this language on a blimp and put it and fly it in the Capitol rotunda because it's so strong. I think it could be used much more than it is now, but it has been, as Alex will point out, it has been the basis for some important decisions in Minnesota.
Well, let's turn to Professor Klass now. This was, again, 1971, and maybe you can set the scene for us in a broader sense and tell us what else was happening around the country at that time.
Sure. Well, as Chuck said, this was an exciting time for environmental protection. You have the first Earth Day, you have the creation of the Federal Environmental Protection Agency, you have the beginning of the enactment of all of our major federal environmental statutes. In these years, you get the Clean Water Act, the Clean Air Act, and the National Environmental Policy Act was a couple of years before. And so, of course, you have states getting into the action. And a lot of what was happening in the states, it took different forms. I've written about this area, and I kind of call these all what I term public trust principles. So they take different forms. One form is statutes like MERA. So, Joe Sachs has already been mentioned. He was kind of at the center of really building a modern environmental protection movement, and was a great water law scholar as well, was a fabulous mentor to me and, so many environmental law professors as well, died a few years ago, but, was so vibrant, so central to these trends in the law. So, he, because he was a water law expert, he was very familiar with the common law public trust doctrine. Which is an old Roman doctrine that basically says the sovereign needs to protect certain resources on behalf of the public. It got adopted in England, and then of course we took most of our early law from England as well, and was recognized in some early Supreme Court cases right around 1900. The most famous one is the Illinois Central Railroad, which involved when the Illinois legislature decided it would be a great idea to sell the entire Chicago harbor to the railroad. And then the legislature thought maybe that's not such a good idea. And they repealed the law and rescinded the contract. And of course, the railroad sued. And the dispute went up to the US Supreme Court that said, no, there are certain resources that the state holds and has to protect on behalf of its citizens, both for present generations and future generations. Typically, those have been limited to submerged lands and water resources. And so,
Why is water where it starts?
why is water where it starts? Think about, the Roman Empire, think about England and even early America. Our water resources are everything. It's shipping, it's fishing, it's people's livelihood, so that these were special resources. So we have this public trust doctrine that Joe Sachs decides is a great idea to kind of dust off and use not just for commerce and for fishing, but actually to protect resources itself. He also then decides to work with, he's at the University of Michigan at this point, he ultimately moved to UC Berkeley, works with the Michigan legislature to pass their version of MERA. Folks like Grant and Chuck and legislators here get into the action, and Minnesota passes the Minnesota Environmental Rights Act. And maybe about 10 states did the same. I would say Minnesota's has been the most durable and the strongest, even more so than Michigan, which litigants under the Michigan law have sometimes faced some standing hurdles in the courts. But MERA was used right away in the courts, and there were very expansive interpretations of MERA from the Minnesota Supreme Court to protect wetlands, to protect birds, to protect a whole host of resources, because unlike the public trust doctrine that historically was limited to water-based resources, if you look at the definition of what protected resources are in Minnesota, natural resources are all mineral, animal, botanical, air, water, land, timber, soil, quietude, recreational, and historic resources. So that's all set out in the statute. So you don't have that limited scope that you might have in the public trust doctrine. So, in Minnesota, MERA ends up being, very protective of the environment. But in other states that don't have statutes like that, there was a lot of litigation under the common law public trust doctrine, and Supreme Courts in California and Louisiana, even in North Dakota and in the East Coast states, decided to kind of allow litigants to use the public trust doctrine to protect, in most cases, water-based resources, but in California and some other states, also wildlife resources, sometimes parkland, more broadly than that. Illinois has a pretty expansive public trust doctrine as well. And then also at the same time, again, early 1970s, you have a lot of states are redoing their state constitutions. They're doing constitutional conventions, they're adding to their Bill of Rights. And so you have states that then create new environmental protection provisions and put MERA-like provisions, not as explicit, but provisions that say, citizens have a right to clean air and clean water. For the most part, courts didn't interpret those constitutional provisions in a way that gave any new rights to individual citizens. Oftentimes they were interpreted as saying, well, this just gives the legislature a more opportunity to create environmental protection statutes, which of course the state could do anyway without that constitutional provision. But more recently, the Pennsylvania Supreme Court in the last 10 years has, for the first time, started interpreting their provision, their environmental rights provision in their constitution broadly to push back against some state legislation friendly to oil and gas interests, because there's a lot of fracking in Pennsylvania, and you had local governments that wanted to create more zoning ordinances and limits on that activity. The state said, nope, that's all preempted. We get to decide what all the oil and gas laws are going to be in the state. Local governments challenge that under their environmental rights amendment, again, similar to MERA. And the court said, that's right. The state has violated the environmental rights amendment by not protecting natural resources and by not letting local governments do that. So after decades of doing nothing with their constitutional provision, all of a sudden the Pennsylvania courts are using it quite aggressively. And just to bring us up to the present, it was election day on Tuesday, and in New York State, New York voters voted by more than 2-1 to create a new amendment in their Bill of Rights that gives the right to clean air, clean water, and a healthful environment to all citizens of the state of New York. So, maybe, there's, just like in the early 1970s, we kind of had a big focus on environmental protection, clean air, clean water. We may be seeing that again. As Chuck said, there's a lot more pushback now from the other side. But I'll be interested to see what the courts do in New York with that new amendment and how litigants use it. Just to sort of round out, these initial comments, my involvement with MERA started when I started practicing law in Minnesota in the early 1990s. I was around when MERA was passed, but I was not a lawyer then in 1971. So, I had lots of MERA cases when I was in private practice. Sometimes I represented plaintiffs, sometimes I represented defendants. So I was very familiar with MERA. But then when I moved into academia in the early 2000s, the first class that I taught was property. And there was a unit on the public trust doctrine. And I had never heard of the public trust doctrine. Maybe I'd learned it in my property class, but I'd forgotten a long time ago. It had never come up in my 10 years of law practice. And I started digging into it. I'm like, oh, well, this is just a common law version of MERA, which of course it is. But that is what sort of got me interested in all of these different strands of what I call public trust principles. There's common law principles, there's statutory principles like MERA, and there's constitutional provisions as well. And it's fascinating to look at how courts address claims for environmental protection when litigants will use them together. So you have a common law public trust doctrine, but it's bolstered by an environmental protection statute or a constitutional provision. And so those are often the most effective means of getting good results in environmental protection cases, is when you can kind of convince the court that all of these public trust principles, both in the legislature and constitutions and as common law, work together to protect the resource in question. What we've often done in Minnesota, and I wrote a law review article about this, is once MERA was passed, we only focused on MERA, which makes sense. It's a statute, it's super broad, there's good case law. Why would you rely on kind of a fuzzy old Roman doctrine if you've got this nifty statute? But as a result, the common law public trust doctrine case law in Minnesota is very underdeveloped. Because until the White Bear Lake litigation that many people on this call were involved in, there really had not been litigation that involved both a common law public trust claim and a Minnesota Environmental Rights Act claim. So the courts really hadn't had the opportunity to develop our common law public trust doctrine sort of 1970s Earth Day forward as it did under the Minnesota Environmental Rights Act. So I'll stop talking for now, and curious to see people's reactions and follow-up questions.
Right, and we've got a few questions in the Q&A, so we'll save some time for that at the end. We'll take a few minutes at the end to answer those questions. Well, Professor Klass, how do those two work together? For instance, in the White Bear Lake case, why would you need them both?
I think it's helpful to have both. Because in the White Bear Lake case, and in theory, in any case, you can get the result that you want, which, at least from the plaintiff side, is going to be protecting the resource in question, either through MERA or through the public trust doctrine, if it's the right type of resource. So, White Bear Lake, you're talking about water and submerged land. So it's a classic, common law public trust resource. So you could protect it either using the common law public trust doctrine or through MERA. But there's certain resources, let's say you don't have a water-based resource. In most states, the common law public trust doctrine is not going to get you very far. You need a broader statute like the Minnesota Environmental Rights Act or a constitutional provision that has been interpreted broadly by the courts, like in Pennsylvania for now. So for instance, there were lawsuits across the country brought by a group called Our Children's Trust to try to use the common law public trust doctrine to address climate change. And basically the atmosphere is a public trust resource, and therefore there's an obligation on states and the federal government to address climate change. And both at the federal level and also at the state level, those claims, although they brought a lot of awareness to the youth climate movement, those have been unsuccessful, in part because if you're focusing on the history of the common law public trust doctrine, it's not a traditional, water-based, resource. Whereas a statute like MERA might be more helpful. A limitation of MERA is that, if the action is being done in a way that is consistent with a permit that's issued by the Minnesota Pollution Control Agency or the DNR, there's limits on how you can use MERA. I think Chuck's going to talk about a different provision of MERA that deals with, permits that are not good enough. But the provisions that the provision of MERA we've talked about so far, you kind of have a permit shield in some of those instances. You don't have a permit shield in a common law public trust doctrine claim. Legislation can be repealed in a way that the common law really can't. So there's kind of pros and cons to both. There's some limits on the use of MERA with regard to actions against farming operations. Those don't exist in the common law public trust doctrine. So it kind of depends on the case. But I mean, my view is that to the extent you have more than one source of law, it just makes your claim stronger. And so I think it's in the interests of Minnesota and really in all states to have both a developed common law public trust doctrine, case law recognizing that doctrine, as well as strong interpretations of the Minnesota Environmental Rights Act too.
Well, thank you. I'd like to turn to Grant and Chuck now to have them talk, as you suggested, about how MERA has been used over the years, and Grant, what your frustrations with it have been, or what your satisfactions with MERA have been.
Well, I think the most important thing I'd like to say is that you can't use these laws without public opinion, or as Abraham Lincoln said, nothing can be accomplished without public sentiment. And the reason that we were able to get the support of the Republican legislature in '71 was because there was an enormous public opinion developed, largely because of the reserve mining dumping without any treatment whatsoever, all those tailings in the Lake Superior. So by the time that the Earth Day occurred in April of 1970, you had 1,000 students show up at Kaufman. I remember going over to give a speech at River Falls that night, and I read the Star, the Minneapolis Star. There were 15 articles about pollution, separate articles in the Minneapolis Star, that one issue. So there was great interest in the environment, and that is what you have to have. Just having laws enough are not enough. For example, after the reserve case, something terrible happened. The Senate and the House in Washington repealed the Federal Enforcement Conference. And they did that because they knew that is one reason we were able to fight reserve mining. I think I know who was responsible for that. I can't prove it, but a certain congressman from Minnesota.
From Minnesota.
You had to have something like that, which provided hearings, just like the Minnesota Policymaking Board of the PCA, which we've now lost, thanks to not Republicans, but Tom Bach, a Democrat at the time and majority leader. So in some respects, the best thing that happened was Gordon Rosenmeyer, an independent conservative, who came up with the idea of the policymaking board at the PCA. And in fact, when I got appointed, I got acquainted quite closely with Gordon Rosenmeyer because he came over testifying on behalf of a polluter, Hennepin paper, but he gave the most probably brilliant presentation to our board. And so Hennepin paper was successful in that regard. And after I talked to Gordon, I said, how'd you ever come up with this idea? of having an advocate as the administrator, which is what I was, and then a board that would decide policy. And he never told me how he developed that, but it was
And we should mention,
1965
Grant,
and 1967. And I said, you know, enabled me to be an advocate, much more so than a regular commissioner. He
But
said, well, I
that's-
didn't have you in my mind for an advocate. So I got a good laugh out of that.
yeah. But as you know, that citizen board does not exist anymore. It was,
No, it should be restored. And one thing that bothers me is that we got about 80 environmental groups in this country, in this state. And not one of them has taken the lead to restore that. And pretty soon that's got to happen. And it takes some leadership from politicians like Willard Munger.
Like-
Great.
like the leadership that
Mr.
you and
Environment,
Rick
according to the
provided
biography on
for
him.
years.
Yeah.
Okay, let's turn to Chuck. As you've watched the progression of MERA over the years, what are your thoughts about how well it works or doesn't work?
Well, Alex pointed out that of the law of the 10 states that adopted this type of a statute, Minnesota is the strongest. And it's not perfect.
Right now.
And there's some cases that I thought weakened it a little bit, but I certainly wouldn't suggest trying any legislative amendments at this point, because that would just invite the bad guys to come in and try and weaken it. But if we had the kind of political support that we had back then, I would incorporate some of the bonding language from MEPA, the Policy Act, that allows the plaintiff to avoid posting a bond when they sue public bodies, because that's a big stumbling block in many cases. And I would do something about the farmery exemption, and I would allow attorney's fees for plaintiffs where the court finds in its discretion that the plaintiff has served a public interest. And my big problem with the two statutes that you wrote about in your article, Stephanie, is with MEPA, and that is that we don't require environmental impact statements in Minnesota. All we require is an environmental assessment worksheet, which sometimes can be voluminous and look at all kinds of impacts on the environment of a proposed project. So what's wrong with that? Well, it's related to the feasible and prudent alternative standard that is both part of MERA and MEPA. An environmental assessment worksheet doesn't require you to look at alternatives. You just look at the project. So how can you determine whether there is a feasible and prudent alternative if the environmental review process doesn't require the examination of alternatives? It also doesn't require the examination of social and economic impacts. So the eco-justice aspects of a project are out the window unless you do an EIS. So I've been talking about this for 30 years, but it hasn't changed. I don't see any hope that it will change unless somebody brings some litigation on it, maybe under Section 10. But that's my main gripe about the environmental administration of environmental laws. But I think the Environmental Rights Act itself is working well. It hasn't produced a flood of litigation as the opponents predicted. So I'm very proud that we got that thing passed back 50 years ago, which is so long that some of you listening, your parents weren't even born then.
Well, I'm glad you're not tired of talking about it after all these years. Well, I've got an eye on the time, and I wonder, Kevin, if we have any questions that we should respond to in the last few minutes here.
I think we do. I just wanted to note that Alex has her hand up. Alex, did you want to add something on Chuck's last point?
Yeah, I did. The attorney's fee, the fact that there's no recovery of attorney's fees and experts' fees, I think is important and does limit the amount that MERA is able to be used. These are expensive cases to bring because unlike a Minnesota Environmental Policy Act lawsuit where basically it's a review of an administrative record, you've got briefs in front of the appellate court. It doesn't, it's lawyer time, but you're not trying a case with a lot of experts. A MERA case, you are going to trial, you need experts. It's very expensive and very time consuming. And so without having, that type of fee shifting provision, I think it does limit the scope. But, I agree with Chuck, it's an amazing statute. I mean, even just read the purpose section of the statute. The legislature finds and declares that each person is entitled by right to the protection, preservation, and enhancement of air, water, land, and other natural resources. They go on to say the legislature further declares its policy to create and maintain within the state conditions under which human beings and nature can exist in productive harmony so that present and future generations may enjoy clean air and water, productive land, other natural resources, and everybody has a right to a remedy for this. The other, so it's an amazing statute. And we've, I think, used it well in the state. And I think, we could use it for a whole host of sort of new challenges for the state of Minnesota as well.
Yeah, great. I do just have a couple follow-up questions. They're related to like what was happening back in the day. So on the issue of attorney's fees, Chuck and/or Grant, was that discussed? Was it proposed and rejected, or did it not come up?
I don't think it came up.
You weren't in the position to be asking for it, it sounds like.
Well, no, I mean, some of the new federal statutes at that time provides for an action by citizens and does allow the award of attorney's fees. And then there's a rule that you can seek attorney's fees against the government if their position has been untenable, but almost never successful.
And what about, Alex also described, constitutional amendments. I'm wondering whether that was ever the focus of any of the advocacy back in the early 70s or late 60s.
Would have been a good idea, but we didn't do it.
Okay.
Didn't think about it.
Yeah, Grant, did you want to add something?
First of all, Section 10, this is a statute that Chuck has been referred to, does not cover actions against a state agency where they haven't passed any permit. So you operate then under the rest of the law, and there's no problem with a bond on the other sections, the limit of $500. So that's important to point out. We don't really have a bond problem, except if you sue an agency like the PCA on a permit or a rule that is in that statute.
Yeah, we're going to get into some of those specific sections a little bit more in the next couple of panels as well. And we'll also touch on the bond issue because as Alex and all of you have mentioned, it can be a real impediment. Alex, did you want to add something?
Yeah, one other thing that we haven't really talked about in this sort of, Stephanie asked about, well, what's really the difference between, MERA and the public trust doctrine? One thing that MERA does not provide that the public trust doctrine does is actually a defense for the state and for state agencies when they're acting to protect the environment. So oftentimes you have a situation where a state will enact a new regulation or apply a regulation to limit development on private property, saying maybe someone can't fill in a wetland. And what does the property owner do? They sue the state or they sue the county saying this is a taking of my property. You have to pay me just compensation. And there's a Supreme Court case in Wisconsin from the 1970s and also some cases in Washington state that uphold the state regulation protecting the environment on grounds that the public trust doctrine requires the state to protect the natural resources. So basically the public trust doctrine provides the state with sort of cover for regulation to protect the environment. And so that's another reason, at least I've argued in the past, that it's important to have both a robust common law public trust doctrine and MERA in the state of Minnesota to actually provide support for our state agencies and our local governments against claims like that. So it can be used, defensively in addition to offensively.
Great. Well, this has been a fabulous conversation. I want to just thank you all for participating. Stephanie for your interviewing, and Chuck and Grant for talking with us about what it was like getting this passed, and Alex for your perspective. We want to make sure that we give everybody a break. And I also want to give Catherine Hoffman, our CEO, an opportunity to say hi and greet everyone. So as we're transitioning, I think that Catherine has a couple of words, and I'll just invite Alex and Chuck and Grant and Stephanie to, you can end your share, I guess, and then you'll be on your way. Thank you again so much.
Yes, thank you. It was such a great call. I'm echoing a little bit.
Okay.
I brought my copy of Joe Sachs' book so that I could hear about his history as well. It's really great to hear from people that were so involved in early MERA. I want to say a little bit about who MCEA is and why we're putting on the CLE. Really appreciate that you are all here and able to attend. We wish, of course, that you'd been able to be with us in person, but hopefully we can do something next year. MCEA is a nonprofit, the Minnesota Center for Environmental Advocacy. We were founded almost 50 years ago. Chuck Dayton actually was one of our founders. And we were founded on the premise that the environment needs good lawyers to protect it because we know that industry has good lawyers. And so we need to be able to match with equal talent and strategy. And that's what we do 50 years later. We use the law as a tool to get better results for clean air, clean water, and climate. MCEA is pretty unique in the sense that there are you all probably know of national groups with lawyers, the Sierra Club, NRDC, Earth Justice, and those are wonderful groups and great partners. It's unusual for a state to have as robust a state level legal nonprofit working on environmental issues as MCEA is. There's probably only a handful of states that even have a group like ours, and most of them probably aren't quite as big. And so I think we're really lucky that, some Chuck and others had the vision back in the 70s to build MCEA, and that we're still around today. And, the panelists talked about how our version of MERA is stronger than a lot of other states. And I do like to think that one of those reasons is that we have MCEA to bring litigation and to protect this law at the legislature, because we also have lobbyists, that has kept it as one of the strongest environmental rights law in the country. The last thing I want to say is that we are a nonprofit and we are funded largely through individual donations. That's over half of our support. There are organizations around the country that pay for themselves largely through legal fees, but you have to be in federal court to do that. As was discussed on this panel, we don't get fee recovery for the litigation we bring under statutes like MERA, and that's really our bread and butter is the state laws. And so instead, our litigation and our work protecting Minnesota's environment is fueled by all of you. And so if you are excited by what you hear today, if you're glad that we have MERA and you want to see it continue to be robust and used, then please make a gift. That would be great. We'd very much appreciate it. And there is a link in the chat as well. So go take a break and we'll see you back here in just a few minutes for our next panel. Thanks.
Okay, welcome back, everybody. So in this session, we're going to take a deep dive into MERA. This is the one that will be really good for students, or if you're new to this area of the law. We're going to talk about the claims, the defenses, some of the leading cases, and with us to do that are three of MCEA's lawyers. So we have Jay Eidsness, Jay, and Joy Anderson, and Melissa Lawrence, who goes by Mel, so I'll refer to you as Mel. Thank you guys for being here and for doing the prep work for this. We're looking forward to your presentation. Mel, I think that you're going to kick it off.
Yeah, thanks, Kevin, and welcome everyone to our CLE commemorating the 50th anniversary of this important statute. I'm going to share my screen. And as Kevin said, we're going to talk about the nuts and bolts of MERA. So how do you bring a MERA claim? What are some of the different pitfalls that you could run into? Some of those were hinted at in our last panel. And what are some strategies that you can use? And we'll highlight some key cases. So as Alex pointed out in the last panel, MERA has a very broad and inspiring purpose. The legislature declared that each person is entitled by right to the preservation of our natural resources in Minnesota. And I also want to point out that it says that everyone has a responsibility to protect these resources as well. And the statute gives us an opportunity to do that by providing a civil remedy, either in administrative proceedings or in court, that's really available to anyone who resides in the state, assuming that they have the resources to bring a district court case or to intervene in proceedings. And there are three different ways that you can get there through the statute. The most common is under 116B03, which is the most commonly used provision. And that allows anybody to bring a civil action to protect natural resources from pollution, impairment, or destruction. And as you also heard a little bit about in the last panel, you can bring a section under 116B10, which is, I think Chuck referred to it as the bad permit provision. You can challenge an environmental quality standard or decision that does not adequately protect natural resources. And you can also intervene in administrative proceedings if there's conduct that's likely to cause pollution, impairment, or destruction. And I also want to note that the legislature didn't stop by providing these broad causes of action. The legislature made sure to specify that all of the rights specified in MERA are non-exclusive. And that's important because in some cases, defendants have tried to argue that a MERA lawsuit was precluded by an administrative process, such as drainage proceedings. And courts have pretty consistently held that those proceedings do not preclude a MERA suit. Instead, MERA provides a distinct cause of action even after those proceedings have occurred. And so what is a person under MERA? And this is important because, as Grant and Chuck explained, this really expands the standing under the statute. And it's also important because under the main provision that's used, 116B03, you can also sue any person. So this kind of shows you who the defendants can be under most of these claims. And the statute defines person really broadly to include any natural person and basically any entity you can think of, including corporations or any other kind of organization. And importantly, it also includes the state or its subdivisions. So you could sue the state not only under 116B10, the bad permit provision, you could also bring a claim that the state is causing pollution, impairment, or destruction through it issuing bad permits. The one exception under the statute is that a farm is not a person. So that means you can't sue a farm for creating pollution, impairment, or destruction to the environment, at least theoretically not. One of the most famous MERA cases came pretty early on as Freeborn County by Tuvison versus Bryson. And that case actually involved a farmer as a plaintiff. He brought a MERA case in response to eminent domain proceedings for a highway that would have crossed a marsh on his property. And when questioned about whether Bill Bryson was a person under MERA, the Supreme Court concluded that an individual who owns a farm can still bring a claim as a natural person under MERA, because the court looked to the context of the rest of the language of the statute and thought it was clear that the legislature could not have intended to preclude him from bringing a MERA claim just because he happened to be a farmer. So that case does beg the question a little bit of whether an individual farmer could be sued under MERA if somebody was creative enough. And as Alex talked about in our last panel, the other common element is that a MERA claim protects natural resources in the state. And this provision is much broader than we would expect to see under other environmental statutes or under the public trust doctrine. Notably, air is included in here, which, as Alex mentioned, is not covered by the public trust doctrine. It includes things like minerals, historical resources, recreational resources, and scenic or aesthetic resources that are owned by the government. So maybe a park could be a natural resource under MERA. And whether you have a natural resource under MERA is usually not a threshold issue, but I do want to point out that the characteristics of the natural resource can become an issue when you start to get into the test for whether there's a material adverse effect. And Jay will talk more about that. The one area where you might see litigation on whether something qualifies as a natural resource is in the context of historical resources. And there, courts usually apply criteria that are set out in various federal, state, and local laws for designating sites as historic properties. For example, the Minneapolis National Guard Armory on the lower left of this slide is listed on the National Register of Historic Places. So in State by Archibald versus County of Hennepin, the Minnesota Supreme Court enjoined the county from demolishing the armory in order to build a jail. And the court held in part that the armory was a protected resource under MERA. But not all cases involving historical resources go so smoothly. There was a case in the Minnesota Court of Appeals involving the Northfield Business District on the right here. And that business district is actually designated as historic on the National Register of Historic Places. But when residents sued under MERA to stop a Target store from being built in the area, the Court of Appeals feared that interpreting MERA to count this as a historical resource would create barriers to competition, and it would allow business owners in the district to prevent big box stores from moving in. So the court actually said, we don't think this is what the legislature meant when it was thinking about natural resources under MERA. So these cases do create some question about whether historical resources are protected under the statute or what it takes for something to count as a historical resource. Getting into the specifics of the different kinds of MERA claims, the most commonly used is a section 116B03, or sometimes we'll call it an 03 action, which provides that any person residing in the state, including of course organizations, corporations, etc., the state, can bring a civil action for declaratory or equitable relief against any person, except a farm, for the protection of natural resources from pollution, impairment, or destruction. So what did the legislature mean when it said pollution, impairment, or destruction? That turns out to be a really key provision of the statute. And the statute does define that term, and it provides two definitions, which is important because it creates two different kinds of MERA claims with different elements and different burdens that the plaintiff has to meet. The first is a violation of an environmental quality standard, rule, order, basically any administrative decision that can be interpreted as having to do with environmental quality. Or it can include a material adverse effect to the environment, which is the most common kind of claim. But there are sort of two key elements that are part of both provisions. One is it includes any conduct, which again is very broad, just like any person. Any conduct has been interpreted to cover a lot of different kinds of actions, such as in Bryson, the case involving the farmer, it was the exercise of eminent domain. And in a recent case, the Minnesota Supreme Court determined that it also might include the preparation of certain land use planning documents that can be conduct under MERA. And we'll hear more about that in our third panel. The other key phrase is likely to, which I believe Chuck alluded to earlier. It doesn't only cover pollution that's already happening, it covers pollution that's likely to happen. Of course, provided that the plaintiff can put forth the evidence to establish that. The first kind of pollution impairment or destruction, again, is violation of environmental quality standard, rule, or permit that's issued by the state or its subdivisions. And the elements of this kind of a claim are pretty straightforward. You just need to show conduct, a natural resource, and a violation of an environmental quality standard or order. The one exception, as Chuck mentioned, is that you can't bring a claim under this provision if the only violation is the introduction of odor into the air, and that's again to protect farms. An example of this kind of a claim there's a Court of Appeals case, State versus Zander, Zander with a Z, in which property owners were fighting over a highway expansion near their property. And they brought a MERA claim alleging that the project would impact valerian plants, which are state listed threatened species. So that case kind of gives an example of how they needed to establish that in this case, because the issue is whether they needed a DNR take permit for the project, they had to show there's a threatened species that would be impacted by the project, which would require a DNR permit, which the project proponent did not have. They didn't manage to establish that in that particular case because they weren't able to show that the plants were within the footprint of the project. And for this kind of a claim, the burden of proof is pretty straightforward. Also, the plaintiff has to make a prima facie showing of a violation of the standard or rule, presenting evidence, and the defendants can rebut that with contrary evidence. So again, theoretically, it's a pretty straightforward kind of claim to bring, depending on whether you have the resources to bring in the expert testimony that you might sometimes need, such as in the Zander case. And with that, I will pass it on to Jay, who will talk about the second kind of pollution impairment and destruction, which is a bit more complex.
Thanks a lot, Mel. So as Mel mentioned, the other way to prove up a .03 claim is listed here on the screen. So the first step is for the plaintiff to make that prima facie showing that there is a protectable natural resource that is materially adversely affected by defendant's conduct. So as Mel mentioned earlier, a protectable natural resource is defined quite broadly. So this can include, a single species of animal, a stand of trees, quietude, or even scenic views, as exemplified by the case involving the proposed cell phone tower on the outskirts of Ely, steps from the Boundary Waters. So normally the fact that, needing to prove the protectable natural resource is not the stumbling block. It is that the resource will be materially adversely affected by defendant's conduct. So The plaintiff also has to make this prima facie showing, and proving this involves a balancing test that reflects the need to protect the environment while recognizing, as the Court of Appeals has done before, that nearly every human activity has some kind of adverse impact on a natural resource, and that MERA cannot be construed to prohibit virtually all human enterprise. So courts are trying to strike this balance between allowing development and other actions in the natural environment that will affect the natural environment, but prohibiting those that will provide a material adverse effect. Next slide, please. So in order to prove that material adverse effect, Minnesota courts have adopted the 5 factors to consider that you see on this slide. So these factors were developed from Michigan case law interpreting the Michigan Environmental Protection Act, which, if you were listening to the first panel today, you heard Chuck, Grant, and Alex discuss that MERA was modeled after. So the case law developed in Michigan was answering the question of when an act affecting a natural resource is sufficient to justify judicial intervention. So the case announcing these 5 factors is the Schaller case, and it slightly modified the Michigan factors to help guide Minnesota courts to determine whether conduct has a material adverse effect on a natural resource. So one important thing about these factors is that they are non-exclusive. You don't need to allege or prove each factor to successfully plead a .03 claim. The weight given to each factor and the potential impact of the proposed action will depend on the type and characteristic of the natural resource involved in the specific case. So as Mel alluded to earlier, it is important when developing a MERA case to carefully consider what natural resource or resources are allegedly threatened by the adverse conduct. So simply asserting that a marsh will be destroyed by a proposed highway improvement will be less persuasive and less likely to succeed than if you can assert that, perhaps there's unique habitat in the marsh that supports a population of endangered species or threatened species, and that habitat will be destroyed if that hypothetical highway was built. Next slide, please. So courts in Minnesota have on numerous occasions kind of gone through the Schaller factors and explained why or why not they are met. And one of those cases was the Friends of the Boundary Waters versus AT&T, the aforementioned case involving the cell phone tower on the edge of the boundary waters. So the natural resource at issue there was the scenic views that many of us are familiar with in the boundary waters. So the district court's findings focused on preserving those scenic views that do not include any evidence of human existence. That's one of the main reasons why people go to the boundary waters, is you can look out across lakes and wilderness and not see any human impact. So on appeal, the Court of Appeals faulted the district court's subjective conclusion that the tower would have a severe effect on the scenic views, noting that the evidence submitted at the district court demonstrated that only a portion of the tower would be visible from less than 1% of the lakes in the boundary waters, and that several of those lakes where the tower would be visible already had signs of human existence, such as cabins and small motorboats. As to the long-term effects factor, the Court of Appeals noted that the tower just simply could later be removed, and those affected natural resources, those scenic views, would be restored to their original condition. The Court of Appeals also concluded that the proposed tower would not have a significant effect on other natural resources, and that while scenic views without human interference were finite and limited, they were not significantly decreasing in number. So in sum, after reviewing these factors, the Court of Appeals held that the plaintiff failed to present that prima facie case of a material adverse effect on the scenic and aesthetic views in the boundary waters. Next slide, please. So there's been a number of discussions today about affirmative defenses, and this came up quite a bit in the first panel. And there are a few that I want to talk about today. The first defense to a .03 claim can apply if there are no feasible and prudent alternatives to the alleged environmentally destructive conduct, and that the conduct is consistent with public health and welfare in light of the paramount concern for the environment. So the big takeaway of this affirmative defense is that the defendant's burden here is extremely high. So in evaluating the evidence proffered by the defendant, In State by Powderly versus Erickson, the Minnesota Supreme Court stated that the trial court is not to engage in wide-ranging balancing of compensable against non-compensable impairments. Rather, protection of natural resources is to be given paramount consideration, and those resources should not be polluted or destroyed unless there are truly unusual factors present in the case, or the cost of community disruption from the alternatives reaches an extraordinary magnitude. So case law discussing this affirmative defense agrees that in order to be an alternative, that alternative has to allow the conduct to proceed in some fashion. So using the Freeborn County versus Bryson case that Mel mentioned earlier, an alternative to the proposed highway that would bisect the marsh was an alternative highway route that went around and preserved the marsh. So simply saying we don't need the highway doesn't need to be here, that is not going to be an alternative. You have to show that the highway can be built, but it can be built in a manner that will not destroy the natural resources that you are alleging will be materially adversely affected. So alternatives that, quote, frustrate the very purpose of the project are not alternatives for the affirmative defense. The second element to this defense is that the conduct at issue is consistent with and reasonably required for promotion of the public health, safety, and welfare. Now, there's not a lot of case law discussing this consideration. There's one case where the district court decided to allow demolition of a building that had permit and code violations, but that decision was reversed because the appellate court concluded that those violations could just be remedied, or the building could be renovated, and then those violations would be eliminated. So we've talked earlier today about economic considerations. This came up quite a bit in the first panel, and I know our panelists spoke about how this is a really powerful piece. And in assessing this affirmative defense, economic considerations alone will not justify application of the defense. So as the Supreme Court mentioned in one of its many reserved mining decisions, it is only where the likelihood of danger to the public is remote and speculative that economic impacts, which are devastating and certain, may be weighed in the balance to arrive at an environmentally sound decision. So just merely arguing that an alternative is too expensive to implement won't hold much sway in district court. So the other defense I want to mention here is known as the permit shield defense. So MERA cannot be used to challenge conduct authorized by a lawfully obtained permit, such as a discharge or mineral extraction permit. So if someone were to assert a .03 claim against a mining operation for effluent discharge, asserting that the effluent is destroying aquatic resources, the affirmative defense will come into play if the mining permit that the mineral extraction operation has authorizes the discharge that is allegedly destroying the facility, or excuse me, allegedly destroying the environment. So that kind of sums up the material adversely affects portion of a .03 claim. So Joy is going to talk through another claim known as the .01 or the .10 claim.
Yes, thank you, Jay. So I am going to be talking about what's called, I guess, the bad permit provision, or it could be called the return to sender provision, actually. So this is a .10 action, and it's very different from a section .03 action, which, as Mel and Jay have been talking about, really challenges the violation of an environmental standard or other conduct. And if you have a permit or other kind of environmental rule that allows you to do that pollution, you can't be sued for it under a .03 action. But a .10 action is really different. It challenges the environmental quality standard itself and says that it is not adequate to protect the environment. But the remedy that you have here is pretty narrow. Instead of getting the environmental quality standard necessarily overturned, the standard is sent back to the agency that promulgated it for reconsideration. Next slide, please. So what are the elements of this kind of claim? First of all, it's for a challenge to an environmental quality standard, limitation, rule, order, license, stipulation, agreement, or permit. So that part is really broad. It's really any kind of action taken by an agency that would affect the environment. So parts of this claim, the the part about who the plaintiff is also really broad. The plaintiff can be any natural person, the attorney general, the state, any subdivision of the state, any legal entity. That again is really broad, and that's very similar to a .03 claim. However, there are parts of this claim that are also narrower. For example, the defendant can only be the state or an agency or instrumentality of the state. So you can't bring this claim against any other kind of person, which makes sense because it's the state that's promulgating these environmental quality standards. Also, you cannot get just any kind of relief. Your relief is limited to declaratory or equitable relief. So this is not a damages statute. And you also have to show that the applicable appeal period for your environmental quality standard has elapsed. So this is not intended to be a claim that is brought immediately against a rule that is just passed. You have to usually wait until the any kind of appeal period has passed, the rule or regulation is in place, it's operating, and it's operating to pollute or impair the environment. And in that case, you've got a section, a .10 claim. Next slide. So how exactly does this work? Because it's a very different statute than a normal kind of civil claim where you bring a complaint, you go through discovery, you maybe do summary judgment, you finally get a trial. This doesn't work that way. It's got a very different procedural trajectory. So first of all, the plaintiff has to prove a prima facie case. So what does that include? You have to show that you have an environmental quality standard or rule or all those other things, but I'm going to just say environmental quality standard that is inadequate to protect the air, water, land, or other natural resources within the state from pollution, impairment, or destruction. So this has some of the same kinds of elements that we've been talking about with a .03 claim. The broad natural resources definition is present. The pollution, impairment, or destruction definition that we've been talking about is present, but it has to relate specifically to the environmental quality standard. And it has to be shown in this first step with material evidence. Next slide. So what happens after that? Once the plaintiff makes this initial showing, then if you get that, then there's a remand to the agency. The district court has to remit this environmental quality standard back to the state agency that initially promulgated it for reconsideration. And then the agency is required to institute appropriate, whatever that is, appropriate administrative proceedings. And then it's supposed to consider whether that environmental quality standard is in fact adequate or inadequate to protect the environment. And it has to issue an order on that topic. Once that order has been issued, the court retains jurisdiction to determine whether that agency order is supported by the preponderance of the evidence. And that is a higher standard than an agency usually has to meet. Generally, an agency's action simply has to be supported by substantial evidence, which is a slightly lower standard than the preponderance of the evidence. So again, this is a really different trajectory from a normal civil complaint. You don't ever get to trial, apparently. It really just, you go to court, you have to make this initial showing, you go back to the agency, and then only if the agency's decision is not supported by the preponderance of the evidence does the court have anything to say about it thereafter. So it's really back to the agency. The agency has to reconsider its own action. And that could be a part of why, as it was Chuck, I believe, who said that this has been used so rarely. .10 claims just have not happened that often in Minnesota. And it could be in part, I'm speculating, but because plaintiffs think, well, what am I really going to get if the agency that promulgated this standard is reconsidering the standard? And it could be quite a powerful tool. It just hasn't been used that much yet. And so we haven't been able to see what the results of it will be. Next slide. Because there is so little case law about this provision, about this kind of claim, there are a lot of questions that are outstanding that we don't have case law guidance for. What constitutes the material evidence that the plaintiff has to show as part of its initial showing? What exactly does it mean that the standard is inadequate to protect the environment? Some of the section 0.03 case law about what's a natural resource, what's pollution, impairment, or destruction, that will apply. But some of these other things, we just don't have guidance specifically from the courts about what they are. What if there isn't a specific statutory appeal period for that rule or order that can elapse? Then what do you do? Are you allowed to bring a claim at all? But we don't have answers for these questions in the case law. Next slide. That could partially be changing, however, because there is a case going on right now that is a section 10 claim that we will get to be able to watch as it progresses through the court and see how this kind of claim actually procedurally works. So this case is Northeastern Minnesotans for Wilderness versus Minnesota DNR. It was filed last year in Ramsey County Court. And in the complaint, which includes a lot of information, the NMW alleges that the current non-ferrous mining rules, so for minerals other than iron, basically, are inadequate to protect the boundary waters from pollution, impairment, or destruction. So right now, in the boundary waters themselves, and in a little buffer area around the boundary waters, mining is restricted. But what this complaint is saying is because of the dangers of copper nickel mining, because of the hydrology of the area, because of the pristine nature of the boundary waters, those rules are not sufficient to protect the boundary waters from pollution that could happen if a copper nickel mine is built right next to the boundary waters. So the complaint, because of that, asks for changes to the mining rules that would restrict mining in a larger area in the watershed that is right next to the boundary waters. Next slide. So the interesting part about this is watching how this proceeds through the courts and what actually, how all these pieces of the statute actually play out when you have a claim. So what happened in this case is that NMW and DNR stipulated to a remand for administrative proceedings. So we didn't actually get to see what a plaintiff's prima facie case would look like in this instant because DNR and MNW just agreed we can skip that step. And DNR didn't say whether it agreed that NMW had actually met that burden. So unfortunately, we didn't get to see exactly what that would look like, which would have provided useful guidance for future cases. Then Twin Metals, which is a company that wants to build a copper nickel mine near the boundary waters, intervened in the case, objected to the stipulation, said DNR couldn't let NMW skip that step of presenting their initial case, and moved to dismiss the entire case. That motion to dismiss was denied, and that is currently on appeal by Twin Metals. But in the meantime, the court did in fact remand the case to DNR and required DNR to put out an order in 1 year on the inadequacy or adequacy of the current mining rules. So right now, next week, I think, DNR is opening a public comment period on whether the rules are adequate or inadequate to protect the boundary waters. And if they are inadequate, if DNR decides they are, then DNR will open a rulemaking procedure to amend those rules. So this is providing a really interesting example of how the statute works in practice. And it's going to be interesting to see how things progress here, which could lay out a kind of track for people to follow in the future. Next slide. Oh, sorry, so that's the end of my section. I am turning back over to Jay to talk about intervention.
Thanks, Joy. So another powerful part of MERA is that it allows any party to intervene in an existing administrative, licensing, or other similar proceeding upon a showing that the conduct will result in pollution, impairment, or destruction. So the takeaway here is that MERA allows for intervention broader than Rule 24 of the Minnesota Rules of Civil Procedure, which is limited to civil actions. So citing MERA, an interested party may intervene in a permitting proceeding or other proceeding that are normally limited to just an applicant and an agency. So MERA also states that parties may be allowed to intervene on such terms as the court may deem just and equitable in order to effectuate the purposes and policies of MERA. And courts have generally been guided by the considerations set forth in Rule 24, such as timeliness and prejudice to existing parties. So while you might be able to intervene in a broader array of proceedings under MERA, you will likely need to show what you would normally need to prove up in a Rule 24 intervention, such as, again, timeliness and prejudice. Back to Joy.
Yes. Okay, so I'm going to talk about injunctive relief. And this is a really important part of this statute as well, because obviously when you have environmental damage, there is a lot of environmental damage that's going to be irreparable harm, right? If you have a lake that's going to be polluted, or a swamp that's going to be drained, or trees that are going to be cut down, once that happens, you can't reproduce that environmental resource necessarily. So the MERA does grant broad power to the courts to grant temporary injunctive relief in both 0.03 and 0.10 actions, which can be really important for those actions. And in a 0.10 action, I think it's interesting that the statute specifically gives the court authority to grant temporary injunctive relief while the agency is reconsidering the environmental quality standard. So even though the court kicks the standard back to the agency, the court still has the power to issue an injunction saying, while the agency is considering this, you can't cut down the trees or whatever the issue is. And courts have recognized that their power under MERA to impose an injunction or other conditions appropriate to protect natural resources from pollution, impairment, and destruction, that's really a broad power that they have under this statute. Next slide. So while that is a really powerful tool, there's also a really difficult barrier here because there is a bond requirement. And so the statute says that the court may require a bond in an amount sufficient to repay the defendant for any costs that they might incur because of the delay, because of the injunction. So the statute says may require, which sounds like it wouldn't be mandatory, but the Court of Appeals has actually said that because of the Minnesota Rules of Civil Procedures requirements, a bond is required for any temporary injunctive relief. So that can be a really big barrier to plaintiffs who might not have tons and tons of money lying around that they could put up with the court to get an injunction. So the amount of the injunction really, or the amount of the bond really is within the court's discretion. So an example case is State by Drabick versus Martz. And this is a case, apparently there's a lot of people that want to build towers next to the boundary waters and a lot of people who are mad about it, because this one is actually about a radio tower that they wanted to build next to the boundary waters. And in that case, the plaintiff got an injunction and the plaintiff asked for a $100 bond and the defendant asked for a $15 million bond. So obviously there was a little bit of a discrepancy between those two amounts. And the court ultimately imposed a $1,000 bond, which would be pretty reasonable for a plaintiff. But you can see with the $15 million request, how high of a barrier this could impose to plaintiffs. This is not a case under MERA, but a case that we are involved in Wisconsin. A plaintiff just got an injunction and the court imposed a $32 million bond. And so, I mean, that's just, that's kind of an insurmountable barrier for a lot of plaintiffs. Next slide. So that is our presentation on the nuts and bolts of MERA. So our middle panel here is in between the past of MERA, which you already heard about, and the future of MERA, which we're going to get to next. And so we really wanted to show you how MERA is being used today. And as the last panel discussed, the statute really has a storied past, and there may be important new developments in the future of the statute, as the Minnesota Supreme Court has just put out 2 really important MERA cases. So those will be discussed in the next panel. But now we have any questions that you would like to pose to us.
Great. Yeah, let's have people put their questions in the Q&A box down at the bottom of your screen. You'll see the Q&A. You can just click on that and type your questions in there. Some have already come in. So let's take a look here. One person, I think, is responding to your description of alternatives and feasible and prudent alternatives, and is wondering whether you could use MERA then to argue that we should have wind or maybe solar installations rather than a gas plant. Thoughts on that?
I think that would be a persuasive argument to make. The important thing to keep in mind in discussing alternatives, and really when discussing a .03 claim, is to focus not just on the material adverse effect, but really on the natural resource. So if the proposed gas plant will be, if it's going to affect the globe because of climate change, or if it's going to be built on a plot of land that will require clear cutting, you have to put forward an alternative that would either not emit that carbon that would contribute to climate change, like a wind farm or a solar farm, or some type of way to perhaps also generate the electricity that the gas plant would, while keeping that forest in place that would otherwise be clear cut. So I think an example of wind farm or a solar farm would be a great alternative that could be put forward.
Yeah, another question here. It is now well recognized that any successful solution to environmental issues will need to address environmental racism and the disproportionate effects of pollution on underserved and overburdened communities. Does MERA help address these issues of environmental justice? And if so, how? Any creative ideas there?
That's a really good question. One of the kind of pitfalls that I see right away is that the Schaller factors that I discussed earlier are really focused on, a natural resource. And that's also part of what you need to prove up a .03 claim. And the factors really talk about, a natural resource like fish population or trees, human health. You would have to creatively allege that as an environmental harm, similar to the factors that are discussed in the Schaller case. This is an issue that we see not only with MERA, but in, the companion statute, I call it a companion statute, MEPA, the Environmental Policy Act, of requiring, project proposers to study environmental racism, environmental justice. And that's similarly kind of a, square peg round hole type of situation, and it requires some creative lawyering. But I think it's really important to find solutions to that problem, because I agree with you wholeheartedly that we need to be addressing this issue head on.
Joy, I see that Jill Wynn posted a clarification in the chat. Do you want to just address that? And for folks who don't know Jill, I'm guessing that she's probably representing the DNR in the NMW case. So thanks for that, Jill.
Yes, thank you, Jill. And obviously, you know the case much better than I do. I'm just looking at the docket as things come in. But yes, Jill clarified that the Court of Appeals denied all requests by Twin Metals to take an appeal prior to the end of the case, except for on the standing issue. And apparently that issue was argued today, which I did not realize. So yes, I should have clarified that most of the bases for appeal were denied, and that there was a very narrow standing appeal that is left.
Thanks. Mel, there were several questions sort of related to line 3, and kind of generally, was MERA ever alleged? Could it have been alleged? Can it be alleged now? Does line 3, can we get at that issue through MERA? Do you have any thoughts for folks on that?
Yeah, I do. And it kind of goes to Olivia's question really about environmental justice and the bond as well. I think, what we see is you can always bring a MERA claim, right? The statute's written really broadly. So, theoretically, there are a few different MERA claims you could bring regarding line 3, either probably most likely related to the spills that we saw during construction, right? Because MERA does specify that the natural resource must be located within the state. So impacts to waterways, impacts to treaty resources. I do think that that could potentially be brought under the gambit of the statute. But then there's the burden of proof, right? And you have to actually be able to bring a case in district court where you can contradict findings by an agency potentially, which is often an uphill battle. And MERA does soften that with its different standards and different burdens of proof, but you still need the resources to bring that evidence. And it has to be pretty strong, because in the back of the court's mind is going to be, well, the agency thought this was okay. We're not technical experts. And I think that still does influence their decision making. And sorry, I just was going to mention too, the bond issue is also really significant for a big project like that. And there are cases where really high bonds have been imposed.
Yeah. Jay, you were the one that talked about intervention, right? There's a question here about whether intervening under that 0.09 provision in MERA would be possible in a municipal land use decision. Have you seen any cases related to that? Or what do you think about just the statutory language? Is it broad enough to allow for that?
I think the statutory language is, it's quite broad, and I don't see why you wouldn't be able to, make a good faith basis for intervening under MERA. We've seen MERA be cited to intervene in, county drainage board decisions, for example. It talks about license or other similar proceeding. So I would imagine that land use decision, would fall within that expansive language that the 0.09 statute says.
Here's a question about bird death. So from the sports facilities and other large buildings that have a lot of glass, could MERA possibly be a claim that would be brought successfully against those facilities? Here, we can't give you legal advice, by the way, at this CLE. But what do folks think? What are some of the hurdles or considerations?
Seems so like it would be natural resources. So that seems like it would be met. I mean, it seems like you've got destruction, pollution, impairment, or destruction of natural resources. What do you think about the Schaller factors, I guess?
Yeah. How many birds are being killed? What is their type?
Yeah, what type of bird?
What species do they belong to? All those things would probably matter, right?
Yes. Are those birds critically endangered? Is their population decreasing? And I think really to bolster your claim, if you could identify an endangered species, for example, that they are somehow, more attracted to the light emanating from the facility, or it's in their migratory route, or something really specific tying that endangered species to the facility itself, rather than just this kind of broad claim that, birds run into this building, therefore this endangered species will also run into the building. I think that would be a little tenuous for most courts.
Okay, one last question here, and then I think we'll go on our break. The statute refers to quietude. What exactly does that mean? Have there been cases that have been successful under that provision? What would you have to prove?
Well, quietude, I'm hearing some echo here. Quietude involves, it's basically a lack of noise, right? It's a fancy way of saying quiet. So there have been a couple of cases involving gun clubs or shooting ranges near private property that created a lot of noise. And in those cases, there was expert testimony on background noise levels, and they did testing of the noise from shooting at the gun range to show whether there was a violation under the Schaller factors.
Great. Any last thoughts that anybody wants to provide? Hearing none, I'm going to say thank you so much for all the prep work that went into your presentation. And so we will take a 9-minute break, looks like, and we'll reconvene at 3 o'clock for our final panel. And that panel will be on what lies ahead for MERA. And as people mentioned, there have been a couple big cases decided in the last 2 terms of the court, the Minnesota Supreme Court, so we'll discuss those as well. All right, thanks guys.
Thank you.
All right, it looks like we are back and it is 3 o'clock. The punctual group. So I think maybe folks heard that Justice Lillehog is on the phone. We weren't able to connect him through the video, but thanks for making that work for us, Justice Lillehog. Welcome back, everybody. This is our 3rd panel of the day. We've heard about the history and the origins of MERA. In our first panel, just in the last hour, we sort of took a deep dive into the statute itself and some of the leading cases. And so now we want to look at the future, what is to come, and also talk about the cases of the last couple of terms. Let me introduce the panelists briefly again. And so I'm going to be brief, but everybody remember that everybody's bios are on the website at mncenter.org/CLE. You can read about these folks. With me are Sherry Ensler. Hi, Sherry. Sherry is the general counsel for the DNR. Charlie Nowen. Charlie is the Nowen in Lockridge, Grindle, and Nowen, long time lawyer, has done a lot of environmental litigation. David Lillehog is a former Minnesota Supreme Court Justice. He served on the court for 7 years and also was a U.S. attorney for Minnesota. Looks like Justice Lillehog might be able to join with his camera now. And then,
we're getting close.
You're getting closer, all right. Elise Larson is with us here at MCEA. She's our senior staff attorney and is in charge of our water program. So thank you all for being here today and taking the time. We have a number of topics that we have planned to discuss, but we also want to get to your questions. So again, I'll remind you that we're using the Q&A box at the bottom of your screen. You want to go ahead and put your questions in there. I'll monitor that and try to get to as many of them as the time allows. So let's jump in. Elise, I think that I want to start with you. We've heard about the smart growth and White Bear Lake cases just kind of in passing over the last 2 hours. And I think that we need to get a better grounding in what the court said in each of those cases. So can you kind of give us a summary of each of them?
Absolutely. I was going to say it's always uncomfortable to summarize a 23-page Minnesota Supreme Court opinion, but it's even more anxiety provoking when the author of the opinion is on the same panel as you. So this is my, elevator speech of the White Bear Lake decision, which was quite a detailed opinion, but I've sort of trimmed it down to those issues that I think are most applicable to our conversation today. So in the White Bear Lake case, 2 homeowners associations filed a MERA action under the 116B.03 claim that we just heard about from the previous panel. And that lawsuit was brought against the DNR. There, the associations alleged that the DNR had mismanaged the groundwater appropriations permitting process around White Bear Lake, which they alleged had resulted in White Bear Lake's water levels reaching historic lows. So the DNR challenged this claim, asserting that because it was really rooted in the permitting process, MERA's plain language and notions of agency deference required that the associations bring a claim like this under the 116B.10 claim or the 10 claim. The Supreme Court granted review on this issue and a few other issues, but this is the main one for today. And they held that the associations had stated a claim under 116B.03. Writing for the court, Justice Lillehaug concluded that the associations properly asserted a claim under 116B.03 when they alleged that DNR had adversely affected White Bear Lake when they were, by issuing outsized permits, not considering cumulative impacts, not amending permits, and by not imposing irrigation bans. The court also found that the conduct did not fall into the no action exception that was just talked about by the last panel, finding that DNR was not acting quote unquote pursuant to a permit, rather as the body issuing, reviewing, and amending permits. The no conduct exception did not apply. And the court reached the issue with regard to agency deference, saying that the principle of agency deference does not apply to actions under 116B.03, concluding that a MERA action is really more akin to decisions in traditional courts of equity. So after the White Bear Lake decision, the Supreme Court took another case, and this case arose out of the City of Minneapolis's 2040 Comprehensive Plan. And in that case, a community group challenged the plan, alleging that it caused or would cause pollution, impairment, or destruction of the environment. And the community group sought what was seen as a unique remedy in that case, which was the community group asked for environmental review of the plan, because in general, you do not get environmental review under the Minnesota Environmental Policy Act for comprehensive plans. The district court dismissed the complaint, concluding that because comprehensive plans are specifically excluded from environmental review under MEPA, comprehensive plans were also exempt from environmental review under MERA. And the Court of Appeals affirmed that decision. So that was the issue that the Supreme Court took up, and the court reversed that holding, concluding that MEPA's rules do not apply to MERA, and that MEPA's rules do not define the scope of the remedies that are available under MERA. Writing for a unanimous court, Justice Moore held that, quote, our precedent dictates that an exemption from the broad scope of MERA is not presumed absent express statutory language to that effect. And that MEPA contains, because MEPA, the Environmental Policy Act, contains no express language exempting it from the reach of MERA, no such exception was going to be read into the law by the court. And so those were two pretty big decisions on MERA after what was really a long time where the Supreme Court did not take a case, and it really touched on a number of different questions that had been out there from, what is the interaction between 03 and 10? What is the role of agency deference, and how does MERA interact with other environmental laws and policies? And, we now have a lot of new case law in these areas for courts to wrestle with.
Great, thanks for that background. And we're going to take up a lot of those questions that you just identified at the end. Before we get into those, though, I wanted to go to you, Justice Lillehaug, and just sort of take a step back Elise mentioned that these two cases came after a pretty long dry spell, if you're looking at MERA cases at the Minnesota Supreme Court. And I think that you could say the same about environmental cases in general. I mean, I've been working at MCEA for 16 years now, and could, prior to the last couple of years, count on one hand the number of really significant environmental cases that the court has taken. And just in the last couple of terms, there have maybe been 5 or 6 or even 7. And I'm wondering if it signals a new direction for the court, a new interest in these issues, if you have any comment relevant to that.
Well, thank you for the opportunity to be on the panel today. And before I answer your question directly, which I will, I want to say that my remarks today are in my personal capacity. I was not an environmental lawyer before I joined the Minnesota Supreme Court. And certainly now I'm not speaking for my law firm where I'm senior counsel or for its clients. And I'm also not going to get into the deliberations of the Minnesota Supreme Court on any past cases, because that, of course, is part of the deliberative privilege. And then finally, since I'm just making disclaimers, I'm not going to make any predictions about where the court is going to go in future cases. Now, with all those disclaimers, I think I can say something, which is that while it would be nice to think that there's some unified field theory where the Minnesota Supreme Court decides what kinds of cases, what subject matter of cases they're going to accept and which they're going to turn down, that generally is not the case, because when petitions for review from the Court of Appeals come to the Minnesota Supreme Court, I should say now they take them as they get them. And they apply the criteria of Rule 117 of the Minnesota Rules of Civil Appellate Procedure. So I can tell you these two cases were not part of some general idea we're going to take more environmental cases. In the White Bear Lake case, there was a big unsettled legal question of whether one can sue the DNR for the cumulative effect of permit issuance and alleged mismanagement of ground and surface water regulation obligations. That was a big issue. And I would say the fact it was White Bear Lake made a difference as well, because it's a well-known statewide resource, and because the Department of Natural Resources was asking for the review as well on some questions. The public trust argument, which Elise referred to, and other panelists have as well, was very interesting. And the court had not spoken on public trust since 1947, and that I really followed the U.S. Supreme Court in adopting the doctrine way back in the 1890s. So that was an interesting legal question that had not been dealt with recently. And so it's not a surprise that White Bear Lake was granted review. Now, as far as smart growth, I would say, again, the criteria of Rule 117 were applied. You've got a land use plan for the city of Minneapolis. There really is no bigger land use and planning issue in the state than one for the state's biggest city. So I was not at all surprised when the court took that. It was an interesting legal issue that had not been previously explored. And that I'm sure, that I'm speculating is why that case was taken. But I do know it was taken in the usual course and under Rule 117.
Great, thank you for that. Well, Charlie, let me go to you as we get into some of the substance here. Earlier we heard from Chuck Dayton and Grant Merritt, who were there when MERA was passed, that it was a really different political climate. I think that Chuck said that MERA passed with 100% of the votes in the Senate at the time, and that it was a Republican-controlled Senate. And the same was sort of true at the federal level, that the Clean Air Act, Clean Water Act, NEPA were all passed with large bipartisan majorities. Obviously, now we are in a different position in terms of what we're able to accomplish at the legislature in terms of environmental protection, but the environmental problems haven't gone away. I'm thinking of climate change, obviously, but non-point source pollution, toxics, lots of different issues. At the federal level, many groups have started to focus on litigation as a way of getting at some of these problems, like, for example, the Clean Air Act litigation to get at greenhouse gas emissions. I'm wondering to what degree you, and I'll go to everyone, hoping that you all have thoughts on this, but to what degree is MERA available to Minnesota advocates who want to make progress on some of these issues? What are the opportunities there or some of the challenges that you'd see?
Thanks, Kevin. And let me say thank you to the MCEA for putting this panel together and for having all of us speak with such illustrious speakers, my friend Sherry Ensler, my longtime friend, Justice Lillehog, my new friend, Elise Larson, and of course you too, Kevin, since MCEA has had such a major role in expanding the decision-making on both MERA and MEPA, it's really an honor, and it's particularly appropriate that we have this seminar today. I'm going to step back 1 minute to Justice Lillehog's comments. As he gave all his provisos, I thought, well, this isn't going to be any fun if he's not going to have any insight into what went on. But in fact, as always, he gave an insight. And as I look back at Justice Lillehog's distinguished 7-year career, where he wrote 140 decisions, I have to think that this White Bear Lake decision has to be near the top of the most significant ones that he wrote. He certainly has written other crucial decisions for the state of Minnesota: the Walsh decision, the Bidet-Makaska decision, the summary judgment decisions. But this one, I think, brought back to life, in a sense, the breadth of MERA. The idea that MERA can really tackle something as broad as what it did in this case. And when you talk about big issues, Kevin asked about, can it be used for big issues? I mean, this case addressed water appropriation. You know, that is a very, very big issue in the state of Minnesota, and one that's going to become more and more important as the years and decades go by. And of course, smart growth addressed comp planning, which is also a very significant issue, and maybe can, because of the way it's structured, very interesting decision. Maybe it can lead to some other major litigation using MERA. All the speakers before, particularly that helpful seminar that Mel and Jay and Joy gave on the details of the MCEA, really shows just how broad an impact the MERA can have. And I think that it's certainly something that we can think about creatively in use in terms of climate change. Is there some way to approach climate change issues using MERA? And I think the smart growth is sort of an example of that, looking at a comp plan without a specific project, but still using the Environmental Rights Act to address that comp plan. Could it be used for example, transit planning the metropolitan area? Could it be used in, you know, not just one, but in more than one permits that impact greenhouse gases and therefore the air and the water? I think all that is possibility. And I really have to say that when you read the thoroughness of that decision by the court, back in July 2020, it makes you realize just how much this statute can be used. So I think, yeah, that we are on a new day. And I guess let me just quote the dissent. Justice Anderson, when he said, and I'm going to get the exact language, he said in his dissent, quote, "The reach of MERA is essentially without limit." And I think that gives you an idea of what the dissent said about the majority opinion.
Yeah, great. Do others have thoughts about opportunities, challenges? Sherry, you want to go next?
Sure. One thing I think about as I think about litigation and some of these big issues, especially things like greenhouse gas and climate change, is just hearkening back to the National Audubon case with Mono Lake, which was probably the first big public trust case, that it was not the litigation alone that caused the change. And so if we're thinking of litigation as a way to affect political intransigence, I think that one has to consider, is there a group out there, or do we have the ability to take that litigation, frame it, and have environmental groups use it to cause a movement? to make the case more powerful. And we see that in the Mono Lake case with the public trust doctrine. We see that on the with the voting rights cases in the South. So I think there's great possibility, but I would say it's not going to be through litigation alone. It has to be litigation coupled with something else.
Yeah, I heard Grant Merritt making a similar comment earlier in our first panel. Elise, what did you want to add?
I was going to point out, so I've been at MCEA for 4 years, and the first year that I was at MCEA, we went to the Environmental Institute. And there's always what were the big environmental law cases this year? And I remember very vividly, David Zoll got up and he put up a slide and it said MERA ? Because he couldn't find a single case that year that had been filed under MERA, that had evaluated MERA or thought about MERA. And he asked the question, where is MERA? And I think that the Supreme Court taking these two decisions and really reaffirming the power and the breadth of the law has inspired a lot of new creative thinking around a statute that a lot of people, I don't want to say that they had forgotten about, but they had lost the inspirational quality of what MERA is. And so I do think that these two decisions have really invigorated people who advocate for the environment to think creatively about new ways of using the statute.
That's a very interesting comment, Elise. And it kind of takes me back to the day I really started working on the White Bear Lake case. Now, I had practiced law at Leonard Street in Dayton, and Chuck Dayton was my colleague. And I knew he was kind of a demigod in the environmental movement. And I knew he was one of the essential authors of MERA. But I either I didn't remember or I didn't know that what some of the things MERA contained. And I was really struck by the expansiveness of the statute as I just pulled out 116B and read straight through it. I mean, it is really remarkable. And you covered a number of these points, but the creation of a civil right and a civil duty for every person, that is extraordinary. And it's something you don't very often see in the law. The idea that person is defined so broadly, the only broader definition of person I've seen is in the Texas abortion law that was just argued by the Supreme Court, where basically they allow everybody in the world to sue. The cause of action being very broad, not just because of a violation of standards, but any conduct which materially adversely affects or is likely to materially adversely affect the environment. And the word environment, as you pointed out, is extremely broad as well. The defenses are limited, but then when it comes to the remedy, this is very unusual in statutes as well. But yeah, there's no damages remedy, there's no attorney's fees. Some people wish that were not the case, but equitable relief, necessary or appropriate to protect the environment. Necessary or appropriate, that's an extraordinary grant of equitable power to the court. So I remember just kind of sucking in my breath after I finished reading the entirety of 116B and saying to myself, boy, you don't see statutes like this very often these days, except maybe down in Texas.
Great. Thanks for those responses. Sherry, let's move on to sort of the specifics of the White Bear Lake case and the holding that the DNR in particular, or any agency really, could be subject to what we'll refer to as a .03 action. So a straightforward, the government's behavior conduct is causing the pollution, impairment, or destruction, as opposed to a .10 action, which is challenging a rule or a permit. What do you think are going to be the practical implications of the decision from your perch at the DNR, and just sort of thinking about that as a regulator?
I think the first thing we have to ask ourselves is, are people going to use 116B10 very often anymore? And the reason I say that is because of the remedy. The remedy in a 116B10, which is around permits and rules, is to remand it to the agency and to say to the agency, look at it again, fix the problem, or prove that it isn't a problem. And that is, as opposed to a 116B 0304, which basically allows the court to substitute its decision for the agency decision, and it strips away all deference. And if we look, so the first question I ask myself is, if you don't like a decision the agency makes, wouldn't you rather have or try another decision maker? Why would you want to go back to the agency? So I think that we're going to see more and more 03 and 04 cases, and we are not going to see many 116B 10 cases. The other, I think, practical implication, oh, it looks like Judge Lillehag wants to say something.
Justice, did you have a
No.
comment?
No, I may respond to Ms. Ensler, but no, I didn't raise my hand. I don't
Okay.
think anyone could see me.
So the other is a more practical implication as you look at the district court decision and the district court order. The district court has retained jurisdiction. And that in and of it's not just the retaining of jurisdiction, but the whole order creates a challenge because now the district court has essentially become the permitting authority in the Northeast Metro. So the district court has ordered the DNR to amend permits. We made the initial amendments. They then ordered an analysis. They ordered us to determine how much water could be taken out of the aquifer. The court told us we couldn't issue any new permits. And the court did not like the protective elevation we set at 922. So the court set a new elevation at 923.5, which in effect is a protective elevation. But in amending the permits, everybody should realize that because this was under 03 and 04, and only the DNR was sued, there were two permit holders that intervened, but there are 41 permits that were subsequently amended. And the Court of Appeals ruled that those permit holders have a right to contest a case hearing. And so we're in a conundrum where it is potentially possible that an administrative hearing officer may come to a different conclusion than the district court did. So that is a challenge. And I worry about that less in the initial amendments, which had to do with conservation and a watering ban. But we will be for, and it's no secret because we've been meeting with the communities, but we will before probably summer be amending these 41 water appropriation permits to strip them of water they're currently using. Some of our calculations indicate we're going to have to reduce water appropriation permits by up to 40%. And the implications of that are challenging because, of course, each of those permit holders, I anticipate, will appeal or request a contested case hearing. So I think implementing a court order of that breadth under 03, 04 is very, very challenging, as opposed to when you have a case brought under section 10, which says to the agency, go back and fix the problem. I would say the other challenges is if you read Joseph Sachs' book, he anticipated that, you know, the courts wouldn't become a super permitting agency, but that the legislature would step in and fix the problem. And what the legislature did is just stay everything, but it has not stepped in to help sort out the fundamental problem. And unless the legislature does, you'll be in a situation with the 11 communities out there where you're not going to have the ability to grow or to develop, or the businesses to expand or thrive. For example, we have a dairy out there. We're going to be forced to reduce their permit, and that could be have significant implications for their business. So I think the resulting district court orders can be problematic in terms of implementation.
Yeah. So let me just kind of summarize. It sounds like you've identified sort of three main issues. There are lots of issues in terms of the practicality of implementing the district court order and continually responding to possibly different orders from the district court as the court retains jurisdiction. You've asked a question about the meaningfulness of this point 10 provision now, and whether or not people are even going to use point 10 because they can sue the agencies under point 03. And then the third thing that you mentioned is just sort of legislative inaction. It feels like there isn't going to be a legislative solution. Wondering from the others if you have any response to any of those points that Sherry's making.
I'd like to discuss the question of the relationship between point 03 and point 10.
Yeah.
Let's remember what the White Bear case was about. It was about an allegation, not just about a single bad permit. It was an allegation that there were essentially 70 bad permits plus general mismanagement in about 4 or 5 different ways by the DNR of the groundwater and lake resource. And the opinion doesn't need to get into the full relationship between point 03 and point 10. It says, we do not dismiss out of hand the possibility that the associations could have sought relief under point 10, but we do not understand the associations to be alleging that any single groundwater permit is inadequate. Rather, it's a broader allegation. And then it says there are alternative causes of action. So within the facts of this case, White Bear Lake does not definitively answer the question, is every violation of point 10 also a violation of point 03? And you can make some arguments either way. One of the keys may be whether the remitter under point 10 would make any sense, which would usually be it would make sense generally in the case of a single project or a single permit, or whether the regulator's conduct is of such sweep that it falls within the meaning of any conduct within meaning of point 03. And I'm not giving you any opinion on that or any prediction on that, but I think there's definitely an issue with some arguments on both sides.
Thank you for that. Other responses?
Yeah, if I could, on the political side, and you kind of touched on that in your opening question to me, Kevin, you can't accomplish things nationally. Can you accomplish things in the state? I think the answer to that is, kind of to cut right to it, is no. And if you get to a point where there's an urgent situation, there's at least a chance, I would say. But I think Sherry can certainly confirm for all of us that until you get to that point, there's almost no chance with a divided legislature that there can be a legislative solution to what is the kind of thing that in years past would have been solved by a bipartisan group of sharp legislators to try to fix this issue or address this issue. I just don't think there's any question about it. We just got to go back to some of the comments from Chuck and Grant and Alex about, you know, the start of all this legislation to say that people work together. But I just don't think that's true right now. And my experience has been, not that I'm at the legislature, I'm really not, but when we think about solutions on complex problems involving public bodies, you know, we kind of just write off after analyzing the possibility of the legislature taking care of it.
Yeah.
To kind of follow up on Charlie's comment, I agree. Until there's really a crisis, there's not going to be a fix. And it seems to me that the fix for White Bear Lake is likely to move communities to surface water or augment the lake. And I think once the DNR starts reducing permits, you are going to see that boiling point. What makes me a little nervous is what the communities will ask for and what the potential implications might be to environmental law. Will they ask for the necessary infrastructure, or will they go in and ask for a change in MERA and the water appropriation laws to allow them to continue to appropriate from the aquifer? And I don't know the answer to that, but I suspect in the next couple of years we'll find that out, because I can't believe that there isn't, that at some point the legislature is not going to step in here.
Sherry, I have a follow-up for you. I mean, setting aside that danger that you just sort of identified, is there also a way of viewing it from your perspective as positive, because it is in some ways having the courts exercise the authority gives the DNR some cover to do things that some folks at the DNR may have wanted to do previously? I mean, we don't have to take the water appropriation thing, and maybe we should talk about the PCA since they're not here. But you know, there's a lot of political pressure on the regulator, and having a court order might, in some instances, be really helpful.
You know, I agree with you. I would say in the White Bear Lake case, the scientists at the agency would say that's not the case. They still disagree with the science adopted by the district court. But in many cases, we really look to the cover of litigation or a lawsuit because it is politically challenging to move forward in a way that is protective to the environment. So sometimes we welcome those kinds of litigation.
Yeah. All right, let's move to a different topic. Justice Lillehag, I'm going to go back to you on this one. There is a footnote in the dissent of the White Bear Lake case. It's footnote number 4. And Justice Anderson refers there to the Lujan case and starts talking about standing, and is sort of questioning whether, if and when the case comes back, the plaintiffs would have standing. Smart Growth didn't talk about standing at all, and Grant Merritt, during our earlier session, described MERA as basically intended to give every citizen standing. He was using that term, standing. So I'm just wondering if you can give us any insight on where that issue might be going. Is this going to become more of a challenge to MERA cases? I understand that Twin Metals has raised standing questions in the .10 case that the Friends of Northeast Minnesotans for Wilderness brought. What are your thoughts on that?
Well, if you take a look at footnote 4, it's kind of important how it starts. It says, although not an issue before us, parentheses, yet, end parentheses. So standing wasn't an issue argued in the case. And Justice Anderson apparently felt that it was, however, worth spending some time on. It's a footnote, but it's a really long footnote. It takes up about half a page, single space. So that's observation number 1. And the court, the majority dealt with that pretty concisely by saying we're just not going to engage on the issue of standing. It wasn't argued. Now, courts can, of course, if they feel they may lack jurisdiction, deal with issues such as standing or right in a sua sponte. But this clearly did not rise to that level. And Justice Anderson really wasn't making the argument that under the Minnesota Constitution, there was not a sufficient case or controversy here. There most certainly was. These were homeowners around White Bear Lake and White Bear Lake Association, and they definitely had a real and concrete and discrete interest in White Bear Lake. So the footnote's very much beside the point. On the general topic of standing, I think it is important to understand that there are lines of Minnesota case law that don't follow the federal Article 3 standing jurisprudence. So as a general matter, it's a little easier to get standing in Minnesota than in federal court. And in addition, Minnesota's got a very broad declaratory judgment act that's been interpreted very broadly by the Minnesota Supreme Court. And if you can show something touching on a concrete interest, you're probably going to be okay when it comes to standing. And I'm making these remarks, of course, without regard to any cases that are currently pending or may be brought.
Thanks for that.
Nice to add that caveat, David. Again, we're starting to sink in for all of us. I just wanted to add to this, Kevin, one comment. Let me just finish, and that is, I thought that Judge Nelson in Ramsey County, in her decision in the northeastern Minnesotans for Wilderness case, I thought she had a really nice and crisp discussion of standing. I really did. I thought that was really helpful for the analysis. And it's interesting here. I did not know that, but Joy, I believe, or someone in the audience knew that the argument today occurred in the standing matter for that same case. So that's interesting too. But I really thought she's a very good judge, and she wrote a very nice, crisp, clear decision on that matter. So just if you have a chance to read it, everybody, I'd do it.
Great. Any other thoughts on the standing issue? Sherry, are you moving towards your unmute button?
I am. It's too bad that Chuck isn't on still, because as I read the statute, which is basically any person living in Minnesota with a business in Minnesota can sue on behalf of the environment. I read that as very broad. Twin Metals' argument is you can't read it that broadly, and you have to have constitutional standing to file a MERA claim. And I think that's difficult to argue in light of the plain language of the statute itself.
I haven't looked at those pleadings, Sherry, but are they identifying the federal constitution, or have they identified some provision?
They're identifying the federal constitution. They're applying the federal constitutional standard and saying that the environmental group does not have a sufficient injury, and that they can't actually allege an injury until Twin Metals project moves forward.
I've not understood how the federal constitution would apply to a case that's filed in a Minnesota court on the standing issue, but Elise, your thoughts on that?
I mean, I was going to say, I've struggled with trying to understand footnote 4 from the perspective of you have a Minnesota statute, which governs Minnesota state law, the conduct of Minnesotans, and gives Minnesotans broad authority to bring lawsuits on behalf of the state of Minnesota. And I have struggled intellectually with where that intersects with federal standing, particularly when, you know, the Minnesota Supreme Court has not applied the same constitutional standard to the Minnesota Constitution. And so I do think that there's a tension there that footnote 4 has presented. And it'll be interesting to see. I mean, I guess I haven't done a lot of, you know, particular research on this, but it'll be interesting to see what the, you know, federal question or federal issue is when you're bringing a Minnesota state statutory claim in Minnesota against, you know, a project that's based in Minnesota.
Well, there's one more interesting twist here, which is not only the declaration in .01 that every citizen has the right and the responsibility, but if you take a look at .03 subdivision 1, where it's describing the parties may include the Attorney General, and whether it's the Attorney General himself or another party, the claim is in the name of the state of Minnesota. So if the claim is in the name of the state of Minnesota, and Minnesota, of course, has the natural resources, does that alone confer standing? That would be probably one argument that an environmental claimant might make. So there may be not just a bell for standing, which would be Minnesota's less restrictive standard for standing, but also because this is really a claim in the name of the state of Minnesota. It's a private attorney general statute in part.
Yeah.
I'm really glad that, oh, go ahead, Sherry.
So I was going to say the very interesting thing I think about twin metals or in the Northeastern Minnesotans for Wilderness case is the environmental group sued the state. Twin metals took 4 to 5 months to intervene in the litigation. And neither of the two primary parties thought that standing was even at issue.
Yeah. Okay, let's move to the next topic, which is one that we heard a lot about both in the first panel and the second panel, and that is the bond requirement and how that can be a real impediment for MERA litigants. And I'm glad that you brought up, Justice Volhag, the fact that this is a private attorney general claim, because maybe that could have something to do with getting around the bond requirement. But at least in some of the federal cases, there has been a public interest exception found in certain environmental contexts to get around the bond requirement. What do you think about the prospects of that for MERA litigation, and how should we start to approach that problem?
Yeah, I mean, it is interesting because the federal courts have sort of recognized, right, that there are these certain claims that are rooted in protecting a resource, and those groups that would try to protect that resource tend to not necessarily have the deep pockets that you need to put up large bonds, especially if you want to challenge something really big and really complicated that could have some big significant financial issues, which is, right, all of the creative thinking that we're doing on this panel, right, would be dealing with big issues that could significantly affect the economics of businesses or the government. And I think that, you know, the federal courts have recognized that there are circumstances where you undermine the law if you impose big bonds on groups with lower assets trying to find solutions to big problems. That is fundamentally undermining sort of the purpose of these environmental statutes. And I do think that Minnesota courts have the ability. I mean, if you look at, the bonding requirements, it's very, permissive from the perspective of what that bond could be. And so I certainly think that there is room for Minnesota courts to adopt a similar way of thinking. And I do think that, back to MERA question mark, like where is MERA? I do think that there's a degree to which that there probably are lawsuits that don't get brought because people are scared off by the bonding requirement. And so, I do think that that is one area where there could be some development of the law where you would see MERA become a more powerful tool and a tool that was used more frequently if a similar standard was applied.
Other thoughts on the bond requirement? We had an interesting comment earlier about the environmental justice implications of the bond requirement, which sort of goes to your point, Elise. There are certainly well-heeled communities that can come up with money and others that can't. So there's an effect there. Charlie, you wanted to respond?
I just want to say, I think your comments are spot on this, and it is permissive in the statute. And if I read right, the Duluth Economic Development Authority, there was no bond required, but it was sent back on the bond issue because there were no findings, which suggests to me there can be findings that says I'm not going to require a bond. I think it's probably self-evident that the more specific a project is, the more advanced it is, shovel ready kind of thing, the more likelihood there's going to be a pretty robust discussion about what bond would be required. Whereas in other circumstances where it's more generalized, it probably won't be. So, so you have to kind of think that through when applying MEPA or NEPA precedent to MERA. But I think you're absolutely right. I think this would be a good area to develop, is to see, because that's one change in the law. We talked earlier. I think Professor Klass talked about attorney's fees and whether that was all appropriate. And I go back in history and tried to get some citizen lawsuit attorney's fees here in the state of Minnesota. But bonds really does block some things. It's not just not getting attorney's fees and just the expense of these, but having the bond can really just end what otherwise would be a viable case.
Sure.
I mean, I think that it's notable, right? The two big MERA cases that made it to the Supreme Court were ones that were very well funded by, private parties. They weren't, they weren't brought by nonprofits who, and I think that that's notable. And I think that the bonding requirement is, one of the things that has held some of that back.
Yeah.
I'll also jump in and just say in the White Bear Lake case, now I wasn't involved in the first year of that case, but my recollection was that the state of Minnesota did not ever request that a bond be posted. And I would also note in the, now granted, it was a MERA case brought in federal court with a lot of other issues, but in the Fargo-Moorhead Dam case, Justice Thunheim ordered simply I think it was a $5,000 bond, which we split with the diversion authority.
What about this idea that, go ahead, Justice Wilhog.
The temporary injunction, and I didn't remember there was even a motion for temporary injunction in the White Bear Lake case. I think the plaintiffs wanted a trial because they had their experts lined up and they wanted to put them on the stand. And then in the Smart Growth case, can you remind me, Elise, was there a temporary injunction that was thought there? I would think even if there were, it would be very hard for a city to say, you've slowed down our comprehensive planning process, therefore we're incurring X dollars per day. I would think that would be very difficult for a government entity to allege.
My understanding
is those two cases tell us anything about the bond requirement.
My understanding is that they immediately moved for summary judgment. So they filed their complaint and immediately moved for summary judgment. And that was part of what created the weird procedural posture in that whole decision was that the complaint was filed and summary judgment motion was immediately filed.
And I've noticed in a lot of, and granted, these are MEPA cases, so the projects aren't very far along, but oftentimes the environmental group doesn't even seek a bond. It proceeds forward and litigates on the merit without obtaining the bond, you know, assuming that they're going to get a judgment before any action is taken.
There's a comment here saying that there was a TRO request in smart growth, it was denied, and then it proceeded to summary judgment. What about though this idea that, you know, MERA says that the litigants are litigating in the name of the state. And so if I'm bringing this suit in the name of the state, should a bond be required?
Well, the
Is there
statute,
there?
go ahead.
What's your theory, Kevin, as to why a bond wouldn't be a requirement if the state, for example, is trying to prevent someone from knocking down a building? There may well be massive costs incurred by the private party. Why shouldn't the state provide some security? I don't.
Yeah.
I don't know what the law is on that.
It seems like you're representing a broader interest than, you know, a private litigant, and the analysis would be different. Charlie, what were you
Yeah,
going to
I
say?
suppose the state is litigating qua state or as a landowner or something like that. Maybe, I don't know.
Yeah, I was going to say, I thought
Just-
that public bodies can avoid the bond requirement because, you know, I think the idea is that there's always the ability to pay if it comes to that at some point in time. When you have the power of taxation and stuff like that. But I would say, I don't know about that argument, but of course the statute itself talks about there may be a bond. So I think that probably.
So it sort of contradicts itself there. If that were the intent, yeah, good
Right.
point. All right, let's see, how are we doing on time here? We're pretty much close to the end. I just want to end, I guess, on a positive note, and I love this quote in the Bryson case, so I'm going to end with that and get your reflections on it. So for those watching, if you were looking at the second panel, this is the case that the farmer where he was protecting his own wetland, and Mel had a picture of him there. And so Justice Yedka wrote in that case, he quoted at length from Aldo Leopold from the Sand County Almanac. And so I'm just going to read what he said in the decision. He's quoting Leopold: "All ethics so far evolved rest upon a single premise, that the individual is a member of a community of interdependent parts. His instincts prompt him to compete for his place in the community, but his ethics prompt him also to cooperate, perhaps in order that there may be a place to compete for. The land ethic simply enlarges the boundaries of the community to include soils, waters, plants, animals, or collectively the land. In short, a land ethic changes the role of Homo sapiens from conqueror of the land community to a plain member and citizen of it. It implies respect for his fellow members, and it also implies respect for the community as such." And then Justice Yedka writes, "In the Environmental Rights Act, our state legislature has given this land ethic the force of law." What does that look like for us today? And if we want to ensure that MERA is being enforced as the law of the land ethic. Any thoughts from you all?
Well, I was going to let Justice Lilhaug jump in because he's said a couple of times that, you know, MERA also places a responsibility on citizens, it's not just a it's not just a civil action, but it also seems to call for, citizens to really take a responsible role for protecting the environment. And I think that, Justice Yetka was trying to explain that aspect of the law in citing the land ethic, that's really what we're talking about. Like, part of being a citizen in Minnesota is not just having this right, but also having a duty, that this is part of the obligations of citizens.
Well, his opinion there certainly was more lyrical than the one in White Bear Lake.
So I would say that this was important in the way the state decided to appeal the public trust doctrine. And there was extensive discussion, and I often think of land ethic as connected to the public trust doctrine, because as Justice Simonette said and Justice Mitchell, that the state has an obligation to protect these resources on behalf of the people. So when we were looking at the appeal of the trust doctrine, we did not ask that the court find that the public trust doctrine did not exist. We simply focused on the cause of action. And I do think that ethic is something that has to be not only carried forward by every citizen, but should be carried forward by those state agencies charged with an environment or natural resource mission.
Thanks. Well, it looks like we're at time. Any last thoughts that anybody wants to get in before we have to say goodbye? If not, I just want to say thank you so much for participating in this panel discussion. I think that we could have gone on much longer. There's a lot to talk about. To others who are viewing, thank you so much for tuning in today. And thank you especially for supporting MCEA. As you heard from Catherine earlier, we're a nonprofit, so we rely on your support to do our work, and certainly really appreciate that. This is the last of our CLEs in our Green Beagle series for this year, but we will be doing another series next year. So look for an email from us in 2022, and we'll hopefully have some more engaging conversations. So a big thanks to everybody, and enjoy the rest of your day.
Thanks all.